Judgment in the matter of MS Pakistan versus Secretary of State for the Home Department.
This case is about human trafficking. The United Kingdom is party to both the United Nations Protocol to prevent, suppress and punish trafficking in persons, known as the Palermo Protocol, and the Council of Europe Convention on Action Against Trafficking in Human Beings, known as ECAT. ECAT requires state parties to establish a comprehensive system for the prevention of trafficking, the identification and protection of its victims, and the investigation and punishment of the traffickers. The UK has established a national referral mechanism, the NRM, in order to identify victims. First responders, such as police officers or social workers who suspect that a person may be the victim of trafficking, refer the case to the Home Office. Officials first decide whether there are reasonable grounds to believe that the person may be a victim. If there are, he or she is usually given a period of recovery and reflection, during which money, practical assistance, and if necessary, accommodation are provided. After at least 45 days, and usually much longer, the Home Office will make a conclusive grounds decision as to whether the person probably is or is not a victim of trafficking. This case is about a boy of 16 who was tricked into coming here from Pakistan, where he had been subjected to forced labour and physical abuse from his relatives by the promise of getting an education. Once he got here, that didn't happen. He was exploited as cheap and illegal labour, under the control of adults, and, as the Upper Tribunal put it, a commodity who had been bought and sold. He came to the attention of the police, who referred him to the NRM. The NRM decided, without meeting or interviewing him, that there was no reasonable ground to consider him a victim of trafficking. There is no right of appeal against that decision. Meanwhile, the Home Secretary decided to remove him from the UK, as he had no right to remain here. He exercised his right of appeal against that decision. Both the First-Tier Tribunal and the Upper Tribunal heard his evidence and found that his account of how he had been treated was credible. The Upper Tribunal allowed his appeal, but the Court of Appeal reversed that decision. He now appeals to this court. There are two issues. The first is whether the tribunals hearing immigration appeals are bound to accept the decision of the NRM unless it is perverse, as the Court of Appeal held. If that hurdle is overcome, the second is whether and when a victim of trafficking can claim that removing him from the United Kingdom will breach his rights under Article 4 of the European Convention on Human Rights. This provides that no one shall be held in slavery or servitude or required to perform forced or compulsory labour. In this court, the Home Secretary has conceded the answer to the first issue. When deciding an appeal that removal would breach rights protected by the Human Rights Convention, the tribunal has to decide the relevant factual issues for itself on the evidence before it. It is not bound by the NRM decision, although in appropriate cases it should give that decision proper consideration and weight. This court explains why that concession was rightly made. Also, the NRM decision was an essentially factual decision, and the tribunals were better placed than the official to decide whether the appellant was a victim of trafficking. On the second issue, the European Court of Human Rights has held that human trafficking falls within the scope of Article 4 of the Human Rights Convention. This imposes positive obligations on states to have systems in place to prevent trafficking, to punish the traffickers, and to protect their victims. A positive obligation to take operational measures to protect an individual victim arises where the authorities are aware, or ought to be aware, of circumstances giving rise to a credible suspicion that he had been or was at real and immediate risk of being trafficked or exploited within the meaning of the Palermo Protocol and ECAT. There is also a procedural obligation to investigate situations of potential trafficking. The investigation must be independent and capable of leading to the identification and punishment of the traffickers. In this case, the Upper Tribunal held that there was no real risk that the appellant would once more be the victim of trafficking if he were returned to Pakistan. He was older and more mature now and could go to live in a place where he wouldn't be at risk of further abuse from his relatives. However, there has been no effective investigation as required by Article 4. The police took no further action after passing the appellant on to social services. That failure should be rectified, and no one suggests that an effective investigation can take place if the appellant is removed to Pakistan. Hence, his removal would be in breach of his rights under the Human Rights Convention. Thus, the appeal is allowed and the decision of the Upper Tribunal on this ground is restored. The court will now adjourn.